Picture this. You own a property in Florida. Maybe it's a vacation home, a rental you've been renovating, or an investment property sitting vacant for a few months between tenants. You drive by one day and notice the lights are on. Someone has moved in. Someone you have never met, never spoken to, and never signed a single piece of paper with is living in your house, and until very recently, removing them legally could take months and cost you thousands of dollars. That was the reality Florida property owners lived with for years, and it drove them absolutely insane. In 2026, Florida rewrote the rules. The state made sweeping changes to how squatters are handled, dramatically shifting power back toward property owners and away from unauthorized occupants. Some people are calling it the most significant property rights overhaul Florida has seen in decades. Others are calling it an attack on vulnerable people with nowhere to go. Here is exactly what changed, what it means, and who it actually affects. The old system was a nightmare for property owners. To understand why these changes matter, you have to understand how bad things were before. Under Florida's previous framework, squatters, people occupying a property without the owner's permission, were treated almost identically to tenants in the eyes of the law. Once someone was physically present in a property and claimed to have some right to be there, property owners were largely forced into the formal eviction process to remove them. That process meant filing paperwork with the county court, paying filing fees, waiting for hearings to be scheduled, and navigating a legal timeline that could stretch anywhere from several weeks to several months depending on how backed up the local court system was. During all of that time, the unauthorized occupant stayed in the property. The owner paid the mortgage, the insurance, and the property taxes on a home they couldn't access or use. It gets worse. Squatters who were even slightly legally sophisticated would sometimes forge lease agreements, fake documents showing they had a right to be in the property. Once fake paperwork entered the picture, the situation became even more tangled and expensive to unravel. Some property owners spent over $10,000 in legal fees removing a single unauthorized occupant from a home that was never theirs to begin with. Florida wasn't alone in this problem, but given its massive volume of vacation homes, seasonal properties, and investment rentals, many owned by people who don't live nearby full-time, it was hit particularly hard. What Florida's 2026 law actually does. Florida's 2026 changes created a new, faster legal pathway specifically designed for squatter situations, one that bypasses the traditional eviction process entirely when certain conditions are met. Here is the core of how it works. When a property owner discovers an unauthorized occupant, they can now file a sworn complaint directly with local law enforcement rather than starting in civil court. The property owner must provide documentation establishing their ownership, a deed, current mortgage statement, property tax records, or similar proof. They must also attest under a sworn statement that the occupant has no lease agreement, no rental history with the property, and no permission of any kind to be present. Once law enforcement receives and verifies that documentation, they are authorized under the new law to remove the unauthorized occupant without a court order, without a civil eviction filing, and without the months-long waiting period that used to define these situations. The timeline went from potentially several months down 2 days. For property owners, that is a monumental shift. The law also created serious criminal consequences for people who present false documents, forged leases, fake rental agreements, fabricated correspondence to claim a right to occupy a property. Under the updated Florida statutes, presenting fraudulent documentation to law enforcement or a property owner to justify unauthorized occupancy is now a felony. That single change alone was designed to gut the fake lease strategy that sophisticated squatters have been using to extend their stays indefinitely. The protections that remain. Before anyone concludes that Florida just gave property owners a blank check to throw people out onto the street at will, it is important to understand what the new law does not change. Legitimate tenants with valid lease agreements are completely untouched by this legislation. If you have a signed lease, even a month-to-month verbal agreement that can be, you are not a squatter in the eyes of Florida law. You are a tenant. And the full protections of Florida Statutes Chapter 83 still apply to you. Your landlord cannot use this law to remove you. The formal eviction process with its court oversight and legal timelines still governs your situation entirely. The law also does not apply in disputed ownership situations. If there is a genuine legal question about who owns a property, inheritance disputes, contested sales, title issues, law enforcement is not empowered to remove occupants while those legal questions are unresolved. That requires the courts, as it always has. Additionally, local law enforcement still has discretion in how they handle these situations. Officers responding to a sworn complaint are expected to make reasonable on-site assessments. If something about the situation doesn't add up, if the occupant presents documentation that appears legitimate, if there are children present and immediate safety concerns outweigh rapid removal, or if the circumstances suggest a genuine dispute rather than clear unauthorized occupation, officers retain the judgment to pause the process and refer the matter to civil court instead. The law was written to handle clear-cut squatter situations quickly, not to strip away due process entirely. Why this became such an urgent issue in Florida specifically, Florida has a higher concentration of vacation properties, seasonal rentals, and absentee-owned investment real estate than almost any other state in the country. A homeowner based in New York or Ohio who owns a beachside condo in Fort Lauderdale or a rental cottage in the Keys might not visit their property for months at a time. That created a very specific vulnerability. Properties sitting vacant for extended stretches became targets. Social media and word of mouth within certain communities had made it easier than ever for people to identify vacant properties and coordinate occupying them. Some unauthorized occupants genuinely had nowhere else to go. Others were running deliberate schemes, specifically targeting properties where the out-of-state owner was unlikely to notice quickly, knowing that the old legal process gave them months of free housing before they could be legally removed. Florida also saw a spike in squatter activity following several intense hurricane seasons. Displaced people, damaged properties sitting empty during repairs, insurance disputes, leaving homes vacant for extended periods. All of it created conditions where unauthorized occupancy became more common and more complicated to address. The volume of cases flooding Florida county courts became significant enough that legislators could no longer treat the old process as adequate. The criticism, and it's worth hearing. Not everyone is celebrating these changes, and the pushback comes from people with legitimate points. Housing advocates have raised concerns that the speed and informality of the new process creates opportunities for abuse. A bad faith property owner, they argue, could potentially use the sworn complaint process to remove someone who actually does have legitimate tenancy, writes a genuine tenant whose lease was verbal, whose paperwork is messy, or who simply doesn't have the legal knowledge to assert their protections in the moment. Law enforcement shows up. Civil liberties organizations have pointed out that removing someone from a home without a court order, even someone who arguably has no right to be there, is a significant departure from the due process protections that have traditionally governed housing law. Courts exist precisely to sort out disputed facts, and moving those determinations to a law enforcement officer making a field judgment introduces a different kind of risk. There are also real concerns about vulnerable populations. Not everyone occupying an abandoned or vacant property is running a scheme. Some are genuinely desperate people, domestic violence survivors who fled dangerous situations. People recently released from incarceration with nowhere to go, individuals experiencing homelessness who found an unlocked door. The new law doesn't distinguish between a calculated squatting operation and a desperate person who made a terrible but understandable choice. These are not frivolous concerns, and they deserve to be part of the ongoing conversation about how this law gets applied in practice. What property owners should do right now, whether you think the new law goes too far or doesn't go far enough. The practical implications for Florida property owners are significant, and there are concrete steps worth taking immediately. If you own property that sits vacant for extended periods, physical security matters more than ever. Reinforced entry points, visible security cameras, and regular in-person checks or a hired property manager who conducts them are your first line of defense. Prevention is dramatically cheaper than any legal process, new or old. Document your property's status consistently. Dated photographs, utility records, and maintenance logs create a clear picture of a property that is maintained and monitored. That documentation strengthens any sworn complaint significantly if unauthorized occupancy does occur. If you discover someone in your property, do not attempt to remove them yourself. Florida law still prohibits self-help removal, changing locks, cutting utilities, removing belongings without legal authority. Even under the new framework, the proper channel is filing the sworn complaint with law enforcement and letting the process work. Taking matters into your own hands exposes you to civil liability regardless of how righteous your cause. And consult with a Florida real estate attorney to fully understand how the new law applies to your specific property situation. The broad strokes are clear, but the details matter. And in Florida property law, the details always matter. The verdict. Florida's 2026 squatter law changes represent a genuine and significant shift in how the state balances the rights of property owners against the protections historically extended to people occupying homes without permission. Property owners got a faster, more practical tool. The months-long nightmare that used to define these situations has been dramatically shortened for clear-cut cases. That is a real win for people who were being genuinely victimized by a system that moved too slowly. But faster doesn't always mean better. The guardrails that remain are important. The criticism is legitimate. And how this law gets applied on the ground by officers making split-second field judgments will determine whether it actually delivers the balanced outcome its supporters are promising. Florida homeowners finally have more power than they did yesterday. Whether that power gets used wisely is the question that 2026 still has to answer.